So, the next rule is Rule 609, impeachment by evidence of a criminal conviction. And that rule, long as it may be, doesn't really encapsulate everything about this rule. Namely, it leaves out the fact that what the rule really should say is impeachment by evidence of a prior criminal conviction of a crime of dishonesty. So remember Rule 608, if you just watched that video, we're talking specifically about people's character for truthfulness or untruthfulness. So you couldn't bring in a prior shooting conviction to prove that this guy is violent or a murderer, and that's like somehow a part of his character, and you can't use that for propensity because Rule 404 disallows it, and that kind of makes sense. So remember, we're talking specifically about character for truthfulness or untruthfulness, even when it comes to this Rule 609, impeachment by evidence of a criminal conviction. Just to be clear, the word impeachment here doesn't mean eliciting a contradiction. It just means hurting the credibility of. That's technically what impeachment means. 90% of the time it's done by eliciting a contradiction from a prior sworn statement, but that's not the only method of impeachment. Anytime you try to harp on a witness's bad character, then that is an impeachment. You're impeaching that witness. So when we're talking about impeachment by evidence of a criminal conviction, the crime in question needs to be a crime of dishonesty. And the crime of dishonesty needs to be able to prove that because he was dishonest in the past, he is dishonest now. Remember, this is the one instance, the one character trait that the law allows us to use propensity evidence to prove. If someone was a liar in the past, once a liar, always a liar. Let's get into the actual wording of the rule, and I'll address stuff as it comes up. The following rules apply to attacking a witness's character for truthfulness by evidence of a criminal conviction. Just remember, some people are going to object to you to doing what you're doing, or they're going to try and impeach with prior criminal convictions. I believe Terry Chapin actually has a criminal conviction in this case, and a team might wrongly try to say that Terry Chapin has a criminal conviction. We're allowed to bring that in under Rule 609. No, they are not, because Terry Chapin's conviction was for drunk driving, and drunk driving is not a crime of dishonesty. And that phrase, a crime of dishonesty, will address too. But remember, 609A says it right there. The following rules apply to attacking a witness's character for truthfulness, not for any other trait, by evidence of a criminal conviction. The crime had to occur. So A1 addresses crimes that were punishable by death, not really relevant here. And A2, for any crime, regardless of the level of punishment, the evidence must be admitted if the court can determine that establishing the elements of the crime required proving or the witness is admitting a dishonest act or false statement. The rules of evidence just recently changed, so this is where the prior crime of dishonesty, that phrase, it predates this current wording, but it still means the same thing. Essentially, as part of committing a crime, someone had to make a dishonest statement, and that has to be like an essential element of the crime that they were convicted of. There was a case 2 years ago, the Neptune case, where the deckhand smuggled drugs, and you could have an argument as to whether drug smuggling was inherently a crime of dishonesty. There's some crimes that are very clearly not crimes of dishonesty. There's some crimes that very clearly are. And there's some in the middle. So like you have crimes that aren't, like battery. There's no dishonest statement being made in battery. You can't bring in a conviction of battery to prove that the guy's lying on the stand now. But what you can do definitely is you can bring in a conviction of money laundering, probably, tax evasion. What? Forgery, yes. All examples of crimes of dishonesty, where you're very clearly doing a dishonest act. And then there's crimes in the middle, where maybe there's an element of lying, maybe there's not, and it would be up to the judge's independent interpretation. But that's what 601A2 talks about. Then 609B talks about a specific limitation about using evidence that is over 10 years old. Namely, if the conviction you're trying to elicit is over 10 years old, then it cannot be admissible for this purpose under Rule 609. So even if it's forgery, even if it's battery, no prior criminal conviction over 10 years old can be admissible, except under Rule 609B1. This is one of my favorite things to argue, because it's you can kind of really wave your dick around. Its probative value, supported by specific facts and circumstances, substantially outweighs its prejudicial effect. What this means is that if you are trying to elicit a conviction over 10 years old, it tends to just generally not be admissible because it's too old, it's not relevant anymore as the law sees it, unless it passes an inverted 403 test. Namely, the probative value has to substantially outweigh the prejudicial effect. And that's not how 403 is worded. People get that wrong all the time. Usually the prejudicial effect is outweighing the probative value. This is different. There has to be, the conviction itself needs to be so probative that it outweighs the prejudicial effect. Last year, J.C. Longstreet, the park owner, had a prior conviction of tax evasion. And in this case could be construed to have laundered money from his park via tax evasion schemes. And that's like the whole robbery was a grandiose tax evasion scheme. That was like a way you could take the case, that we colloquially dubbed conspiracy. That prior conviction of tax evasion was 12 years old. So it did pass on this, like essentially the allowance that you're given to use those types of convictions. But the argument could have been made that the probative value, because the defense was pursuing that very specific defense, outweighed the prejudicial effect of using an older crime, and as such should be allowed into evidence. Not a winning argument, I think, legally, but it kind of showed a mastery of the rules. Stuff like that comes up a lot. There usually tend to be criminal convictions, and they like this rule in AMPTA, so I wouldn't be surprised if witnesses are added if more applicable criminal convictions. This applies to Terry Chapin as well. C, D, and E are all addressing different types of convictions, namely juvenile ones, convictions that are on appeal, et cetera, et cetera. Those aren't relevant. I've never seen them used. As they come up, we can address them in like these specific subsets of the rules, but just know 609A and 609B. You can generally impeach the character of a witness by evidence of a prior criminal conviction is A, and B, unless that crime is over 10 years ago. If it is over 10 years ago, it needs to pass an inverse 403 test. And only in that case could an older conviction be used for the character of truthfulness or untruthfulness. It's a really complicated rule, but a really fun one, really long one, really an opportunity to strut your stuff. Tangentially relevant to this case, and it will definitely be relevant in your time doing mock trial. So hope that helped. And next we're going to be moving on to expert opinion stuff. So Rule 702. See ya.